Good morning and welcome everyone, TGIF. Welcome to our CEO live stream. I'm Carl Ranger, I'll be your host today, and I'm joined by Jean-Ray Kruger, our National Manager, as well as Daniel van der Merwe, our National Collective Bargaining Coordinator. Welcome back to the stream, guys. It's great to have you.
Morning, Carl. Thanks for having us back.
Always a pleasure.
Morning, Carl.
Today, I'm really happy to have you guys here. I've actually been excited about this for a while. So we're streaming live on Facebook, LinkedIn, and on YouTube to all our viewers. The stream will be recorded and will be up on those platforms to view after if you can't stay for the whole stream. But today we've got an interesting topic that I want to discuss, some pertinent labor law reform going on in South Africa. 2025 has definitely been an interesting year so far. Budget speech, we'll get into that in a second, Code of Good Practice, the Employment Equity Act, and now NEDLAC's new proposed labor law reform process, which we'll be diving into. First of all, I just want to ask before we get into the main topic for today, any comments on the budget speech?
Yeah, I gather this is where you bite me, Carl. Look, interesting times, and I think it's going to flow into the discussion today, especially if you're going to start looking at, we're going to be talking about high earning employees and where they're proposing thresholds, and where you're also going to sit with these brackets as well within salaries that are changing. Interesting stuff. I know most of the political parties said they won't support any VAT increase. So one of them is going to have to backtrack if this budget is to go through, which should be interesting. I think you'll have a few negative constituents if it's your party backing up. I don't know. Interesting times, a few changes. It's as I said, the bracket thing for me is a big issue because that's going to affect employees the most, because you're going to be moving into a bracket. Your employer is going to be trying to adapt and raise your salary to keep up with inflation. So you're not actually going to get more money, but they're trying to raise the salaries so they can at least catch up. And then ultimately you go into a next tax bracket, and then all of a sudden you're getting less out after your increases before. So it's interesting times. I have my doubts if they're going to be able to push it through. And I'm not a political analyst, but what happens if they don't push it through? So interesting times ahead. But as you say, 2025, very interesting. A lot of changes coming. I don't exactly know why 2025. It's fantastic for CEO because CEOs obviously. This is our 10 years from going nationally, so it's a big year for us as well. So interesting times. I'm not going to get too politically into it, Cole, but those are my 10 cents.
Save it for the podcast, Chandra. We've heard enough about that. Anyway, no, guys. As I said on our previous live stream, we welcome discussion and engagement. So please feel free to pop through your comments in the comment section on whichever platform you're on. It will pop up live on screen for us. And we'd love to engage and take the discussion further. If you have any comments on specific questions or topics, or if you have any questions put through to my two panelists today, there are two top legal minds in South Africa regarding labor. So I'm really, really happy and excited to have them here and to pick their brain a bit. I have a lot of fun at these sessions. I can put them on the spotlight. All right, guys, let's jump right in. So we're discussing NEDLAC specifically. First of all, for all of our viewers, employers, maybe there's some employees tuning in, what is NEDLAC and why is it responsible for labor law reform? Any one of you. I'm not even going to point a finger.
I think this is Daniel's rally.
Look, I thought this one would come my way. So obviously NEDLAC, the National Economic Development and Labour Council, comprised of various chambers. It's actually brought about through an act, the NEDLAC Act, comprising of different chambers. One of them obviously being the Labour Market Chamber, which is comprised of members from organized business, organized labor, as well as government and community as well, with the idea of looking at labor law proposals, reforms, that kind of thing, and then making recommendations based on that. So obviously that's like the epitome of the top body that deals with these kinds of things, precisely the reform we're dealing with at the moment. And then from the process of NEDLAC, it will go through the normal process of going to Parliament, being a bill, public comment, that kind of thing. So NEDLAC basically the first starting point in that process.
Yeah, it's been a while since we've had much or a lot of movement or this much proposed movement within the labor process in South Africa. I'm thinking back to 2019 with the BCEA when they included Section 73A and a few other changes. But I mean, it's been mostly cosmetic in nature. But I mean, we're looking at the Labor Relations Act from the 1990s still. So I mean, in totality, that's when majority of the sections that we work with daily come from that time period. So I do think it's high time that things are adapted. I know the CCMA and the bargaining councils have updated their processes. The Labour Court has embarked on an online, virtual hearing process to just keep up with the times. And just to add to my intro, I thought 2020 was a weird year, and 2025 legally wise, it's quite interesting with all the changes. Jean-Andre, maybe you can explain a bit about how business, labor, and government get together and negotiate these changes.
Yeah, look, if you look at the NEDLAC report as well, it's quite detailed in the meetings that they've had and how many meetings they have. So I think basically all these different stakeholders come together and certain proposals are made. Discussions are had, very much like a normal negotiation setup. So, inputs are given. There's also facilitators to assist with the entire matter, drafters that make certain proposals, and that's how you go through. You see if you can get consensus. Look, the aim was to try and fill the gaps. That is in the current existing law. You've said, we're coming from a 1994 Act or 1995 Act that needs to be updated and to build forward. I think if you look at it as well, it's obviously addressing gaps within the CCMA system, the Labour Court system as well. I'm not going to get into that. That's not really my expertise, but that's what they're trying to do. So basically what these individuals do is they get together, they discuss, they try and reach consensus to basically draft amended proposals. And then ultimately, if the majority of the parties agree, they tend to send that to the legislature. And then obviously it runs its full process before actually becoming an act. So it's a consultation process of stakeholders within the industry. I think at the back end, I will make a comment. If you look at what are the things that the consensus was reached on, and what are the things that maybe only government and Labour agreed on, and only government and business agreed on. It's one of my concerns, but I'll address that at the back end. I don't want to start that. I don't want to start our day like that.
You're not running this, Jean-Andre. I'm running this. We'll address it when I want to address it. Thank you very much. Okay, Daniel. So on this process, maybe you can just give us a current update. So for our viewers who don't understand, are these now implemented yet? Is it just up for proposal? How does it work from here? And maybe you can just address the public comments as well.
Yeah, sure. So, like I mentioned, it's actually been quite a long running process in terms of the history of getting to this report. I think it's almost like 4 years in the making. So now that it's actually finally here, it comes from NEDLAC and then goes through to Parliament, and that's where the public input aspect comes into it. So it's by no means anything cast in stone at this point in time. And the whole point of public comment is so that, once we've had sessions like this as well, and employers can also then provide their input and their comments on it. Because, I'm sure as we'll discuss some of the topics during this session as well, some of them are a bit controversial, some of them maybe some might agree with, some might not. Hence why it has to go through that whole process still. Timeline, I can't give a timeline, but it's not going to be tomorrow kind of thing, So it's good that these kinds of discussions are had so that we can look at the proposals and see maybe where the potential loopholes are. Employers can also see them as well, and to try and gather as much comment as possible, because I think this is a participative process at the end of the day, so it should be, and as much input as possible is always a good thing.
Yeah. And, just on that specifically, CEO is the largest employers organization in South Africa, and we invite our members and employers to please submit their comments through to us, whether it's in the comment section on this platform or on the various platforms, as well as via email, that we can use your comments and submit them to, obviously, NEDLAC for these proposals, whether you're in opposition or agreements of all the various topics that we go through today. All right, guys, jumping into the first topic, and this is, I think, for my side, a contentious one regarding high-paid employees and dismissal remedies. So, Jean-Andre, should employees earning over 1.8 million, very high threshold, this is now per year, should they have fewer unfair dismissal remedies available to them? So just a follow-up to that, is compensation only, so no reinstatement, is that fair, or does it weaken employee rights?
Yeah, look, let's start there. Quite a high threshold. I mean, if you're earning 1.8 million a year, you are one of the higher earners, in the country. So the debate becomes, yeah, but must they get protection? And I think what you firstly need to do is you have to look at what the mandate of the CCMA is, and what also the aim is of a lot of legislation, within the labour sphere, and that would be the protection of the vulnerable employee. So when am I no longer vulnerable? And that's why there's also certain protections with that threshold that the minister puts out yearly for certain protections and exclusions. So my opinion, and if you started why they're saying, listen, certain remedies must be taken away, is obviously a time issue. If you go into a reinstatement scenario, and I think that uncertainty situation, the courts are backed up. You're getting dates at the Labour Court for 2029. Now you're sitting with reinstatement of higher employees. That doesn't just hurt companies, that sinks companies. So, look, I personally, and again, I'll give my personal thought, I think we should rather have a threshold of, listen, if you are above this threshold, contract of employment should really include like private arbitration situations. So that you agree to private arbitrators. And I think that should alleviate the entire issue, because not that I'm saying that those private arbitrators won't get backed up as well, but, there's a lot more options in that regard. Will it diminish your rights? Yes, obviously. But in all honesty, I mean, we work with employers. If I have a member with an employee earning 1.8 mil a year, I'm going to advise you to be cautious when disciplining or dismissing such an employee. Not that I'm saying the higher earners should have and not that I'm saying lower earners, you shouldn't have that type of process in place. But I don't really think it will be diminishing those guys' rights. I think it should be a different approach in saying, listen, the CCMA can assist you to this point, and from there you should be in a financial situation to rather go through private arbitration. And then to finish it off, does it limit the rights of those employees? No, obviously. If you can't, reinstatement's the primary remedy that the CCMA tries to instill, and you're taking that away. And it's about job security. If I'm earning that amount of money, what is the likelihood that I'll get another job in that line? So maybe not. I don't think it's such a limitation. I think there should be. They should look at an alternative in totality from remedies, and it should go to more of a private arbitration situation for those type of employees.
Yeah. Now, so you mentioned now obviously the high earning threshold as well as the lower earning threshold, and I think on the vulnerable employee part, the 73A threshold. So the Minister of the Department of Employment and Labour issues an annual earnings threshold once a year. It's been issued now already this year. We have updated it on our various platforms, but I think it's at about 250 or 260,000 rand per year now. I'm under correction. And I mean that determines the threshold for certain jurisdictional disputes at the CCMA. So 73A, claims for failure to pay amounts owing. Why do you think it's different that unfair dismissals have such a high threshold compared to that? And why I say that, and why I'm asking that, is specifically because the CCMA or the Labour Department see that as, you're not so much a vulnerable employee, you have access to the courts. So why bog the CCMA down with these high stakes disputes? And I think that's what you were getting at. 1.8 mil a year is a lot of money. And, for most South Africans, so the stakes are a lot higher when looking at retrospective reinstatement and that. But why do you think the threshold is so high? Maybe I can give it to Daniel and to Jean-Ray, and then Daniel can give your thoughts.
Yeah, look, I don't know, to be dead honest. I mean, that is if you look at the minimum threshold, it's very specifically calculated. It's a bunch of different numbers in a row. 1.8 sounds like a spitball number to me. I don't know why. The fact that it's so round kind of makes me feel that I don't know if a lot of thought has gone into the number per se. And if you look at I would love to see Stats SA or something like that, just to show you how many employees actually earn over 1.8 mil a year.
You're in the top 1% of the country.
I think you're gonna, So what's the point with a threshold like that? Because how much, and I mean, we appear, and our officials appear in the CCMA a lot. I mean, I've been appearing for 12, 13 years. I think I've seen one case of an employee earning over 100,000 Rand a month in the CCMA. So, okay, I can't speak for everyone, but I don't think they're going to reach the goal that they want to with such a high threshold. You need to be looking lower, in my opinion.
Yeah. So Daniel, I mean, we can assume the thought process behind setting that threshold was to alleviate these kind of disputes because they have access to obviously a high earning capacity and therefore access to the civil courts for these kinds of claims. Do you really think it'll make a dent in the amount of cases the CCMA or even at the Labour Court?
Yeah, interesting one. When I first read this particular proposal, I had to scratch my head a bit because, like Jondo mentions, the 1.8, it really seems like a bit of an arbitrary number and doesn't really have much justification behind it. And to be quite frank, I don't think it will make much of a difference at the CCMA. You know, I think, like Jondo says, I've never seen an employee earning that much in terms of matters we've dealt with at the CCMA. But I think the intention behind it is obviously to alleviate in a certain sense. But I think, in my opinion, there's one or two ways that can also be done without necessarily placing a threshold on employees that earn up to a certain amount, for instance. An idea off the top of my head is, you know, we're all familiar with the pre-arbitration that's meant to take place, you know, when there's legal practitioners involved or a union or whatever the case might be. And I know that that's not a very uniform applied mechanism at a lot of the CCMAs. And for instance, in my mind, that's a way that, you know, it can streamline processes at the CCMA and really get down to the nitty-gritty of what needs to be argued and done without wasting anyone's time or the CCMA's time as well. So as a potential mechanism to alleviate the burden. So yeah, I'm still scratching my head a little bit with this one because it does just seem fairly arbitrary and in terms of especially what the end goal is here.
Yeah. And, you know, if you look at that amount, if you look at the jurisdiction of the various civil courts, if you look at the Maj Court, Regional Court, High Court, their jurisdictions, if you get a retrospective reinstatement or a 12-month award for 1.8 mil, you're in the High Court there. You're not playing in the Magistrates Court. So effectively, the jurisdiction and the authority of commissioners to issue awards to that are that of judges at the High Court, which is quite an interesting thing. But we won't get into that. Moving on, gentlemen. Qualifying periods for unfair dismissal protection. Daniel, is a 3-month qualifying period before unfair dismissal protection reasonable? So we're talking about that probation period now that they're talking about. Does it help businesses hire more freely, or does it make workers more vulnerable?
Look, I think it does both, actually. I think it allows businesses a bit of freedom, you know, to use that period. But I think in the same vein, it also creates a bit of vulnerability for workers because, and the one thing I picked up from the report as well in terms of this proposal is it's not very clearly defined. You know, they talk about the probation period and potentially being applicable to different scenarios. So for instance, in a different industry, it might be a longer probation period kind of thing. But it doesn't talk about what that protection is, if that makes sense. It just says removal of that protection. So it's a bit of a vague one for me, and it's a difficult one to interpret. But I think it would encourage employment, especially if you look at businesses that are looking to employ people potentially without experience, you know, as a way to kind of open the door to that. So that's a potential positive out of that.
Genre, do you think that probation period should be extended? Maybe you can just walk us through the current process and advice for employers dealing with probation.
Yeah, look, this has already been. I mean, in our previous live event, we discussed the changes to the code of good practice, which you can see that they're already addressing these type of elements. I think the probation is difficult for me because it depends. It solely depends on the position. You know, if you can't compare bricklayer with a chartered accountant. You know, it's such a vast, or a program developer or something like that. You have to have a look at what the actual point of the job is and how important is that job and how technical that job is. Because, and I mean, we all came from university. What you learn and what you see happening is sometimes worlds apart. So and the Code of Good Practice has always said, Chapter 8 has said, listen, there's a procedural burden during that probation period. So this isn't anything new, as Daniel says, very vague. It's more of the same for me in regards to that. Again, I'm going to go back. We can say it. How is a commissioner going to implement it? That's going to be a big issue. So it all depends on the scenario. But if probation is used correctly, I think employees are thoroughly protected under the current system. This is for me just going to be an add-on on what we already know in accordance with Schedule 8 and the new Schedule 8 as well.
Yeah, no, I think so. I mean, if you look at the goal of probation, it's like a courting process. So if you look at it in that way, it's to see whether this person is the correct fit, do they have the correct competence, the technical skills, and it is their obligation on the employer to provide those tools and that training to that employee to see if they can meet that standard within that period. Should they not, then employers should still follow the correct probation period and the probation hearings to test whether that person is competent, and then follow those legal processes in terms of the Code of Good Practice, which is also now up for amendment. So quite interesting. Sorry, I'm just busy checking over there. Okay, I got you. Okay, right, guys, moving on to retrenchment and severance pay adjustments. So should retrenchment facilitation periods remain at 60 days or be extended? Thoughts?
Yeah, let me jump in here. I don't think it should be. Retrenchment's already a difficult thing. It's companies. This is not a punitive thing. Organizations are trying to stay afloat. And I mean, if we go back to the budget speech, there's no tax breaks for businesses, stuff like that coming. So, unfortunately, businesses are looking to reduce staff because it ultimately keeps the boat afloat. To extend that period, look, I already have, and I know Section 198A gives that protection because it's large-scale retrenchments and it gives more input from various stakeholders to do that. But it bogs it down. It's not all companies have the luxury of state bailouts. If we look in the steel sector as well, Daniel will know a lot more about that. Some of those large guys, when they close, it's a long process for them. So I don't think it should be extended. I think there's sufficient protection currently. 60 days is a long time for a business that struggles. It's a lot of sleepless nights for people trying to keep the lights on. I think it's already far too long. In my opinion. Okay, granted, I think if you're the one being retrenched, you sit in a completely different position.
Other side of the table.
Yeah, you sit in the different side of the table. But I think as individuals who advise employers on a daily basis, I don't see a need in an extended period.
Yeah, which leads to my next question, Daniel. Does a longer process protect these workers, or ultimately does it just delay the inevitable? Considering that any business that's going through retrenchment obviously has operational requirements that need to be met, such as financial issues or whatever it is. So delaying that process, how do you see that?
Yeah, look, I think, John mentioned as well, it's a process of finality in essence. I mean, a business wouldn't be going through this process if everything was going great. It's really that simple. So by prolonging that process, it doesn't make sense to prolong that process. I mean, if financially there's constraints and it's just getting prolonged and prolonged and prolonged, all it does is just add more pressure. And a lot of the time, these retrenchments are made so that the long-term viability of that organization remains as a prospect. So if you then go and put a further dent into that potential long-term viability, it doesn't make sense. It's a bit of a destructive approach, in my opinion. And I think as well, the 60-day period in itself is a long enough. There's numerous consultations that obviously take place during that time, and enough time for that process, in my opinion.
So with the longer period, now the proposal is to increase severance pay or statutory severance pay from 1 week to 2 weeks. Imagine that the strain that places on a company, together with the longer consultation process or the facilitation process. What are your guys' thoughts on the current stance of severance and increasing it to 2 weeks?
I think let me go first on this one. So I think the important thing to note about the proposal of the increase of severance pay is that it's only going to work prospectively and not retrospectively. So
Yeah.
meaning that only once it becomes promulgated, obviously, then it will apply. So I think if we look at that practically as well, if someone's been at the company for 10 years, for instance, and a retrenchment is then a potentiality or potential, then obviously only the time period after the promulgation will that time be for the 2 weeks. But look, again, it boils down to the issue of, retrenchments there as a means of a last resort. So if you're suddenly creating a further financial burden over and above that as well, I mean, we can think about the impact that might have. It's really, it's a tough one. And I think for employers in this economy as well, that's really not a prospect that it will go down well.
Yeah, look, I think being retrenched is obviously never a win for an employee. Caveat, most of the time it's not a win. Some really do want to be and just get that severance pay. But increasing it to 2 weeks really places a financial burden on companies as well. I mean, a lot of places that are undergoing those financial hardships are struggling to get the 1 week. Now you increasing whatever your contingency plan is in the back for that 1 week for every completed year of service for every employee. Now you're doubling that essentially. Chandra, do you have any comments on that?
Yeah, look, I think it's a difficult one because you want to balance business viability as well as employee protection. So I understand the reasoning behind it. You're trying to soften that blow. If you look at our unemployment, it's getting increasingly more difficult to get a job if you lose a job. It's a difficult one to balance there. But as both of you have now already said, a company going through a retrenchment process is already, their back is a little bit against the wall. Personal thoughts is, and if you have a look at the MIPCO main agreement, it has clear boundaries of 1 week up until a certain period of service. Once you go over that, you obviously benefit more, and that's always felt to me like a very fair process. Give a bit, take a bit. So if I've given so many years to the company, I am allowed to benefit a little bit more versus from start. Now, you're going to get your 2 weeks. And especially now that Daniel's explaining it. So if it gets promulgated, it's only working forward. So now the longer I've been with the company, I'm actually losing a certain amount of benefit versus an individual that comes out of Austin and is in the company right now. Yes, there will be different equations applicable. So it's a difficult one for me. I think it's been long coming. This has been in the murmurs and in the corridors for a while. It is going to place financial strain on a company. But as I said, you've got to balance it between trying to protect and soften that blow versus business viability. So it's going to be hard, but I think it's merely inevitability coming to fruition.
Very diplomatic of you.
Yes,
coming from an employer's
I
love the unbiased opinions that you guys are giving. It's very, very good for our viewers. All right, guys. Something that I just want to address before we move on from severance, and I know it's something that we deal with at the CCM and the bargaining councils. There's a huge misconception that employees are entitled to severance upon retirement or even dismissals or even resignation. Can you guys just clear that up for us quickly? When is a severance payout applicable?
Yeah, let me jump in. I think it comes from an old school, in Afrikaans you call it jarediens, within the previous labor regime. So I think that's where the misconception comes in. But ultimately, severance pay is due when there's an actual retrenchment for operational or a dismissal based on operational requirements. There is a bit of a misconception that severance, it's also called severance when you have a limited duration contract that extends over a 2-year period. But those are basically the two instances that you can get it. I think the reason this misconception is there is it's a generational thing that's been passed down. Very much like people still calling their UI-19 a blow card. So it comes from that's how your dad did it, and that's how your dad taught you, and so I think that misconception is still there under people that don't really know the labor legislation all that well.
I think this labor law, and I'll call it a reboot in the process. We're looking at all the legislation. It's slowly being repealed and amended. I think it's a good place to sort of reform the thinking that goes on in South Africa regarding labor and how the employee rights and employer rights are balanced more fairly across the board. Speaking about fair balance, Daniel, your realm of influence. Socio-economic protest action limitations. Should protest action, the notices, expire after 24 months?
I think long answer short, yes, I think so. Given the current way Section 77 is written, it kind of, once that notice has been issued, or once NEDLAC has considered the notice, it's basically in action or in play for perpetuity. So I think we've often seen it was a few years back as well. There's that COSATU notice that comes out every now and then. It's that same Section 77 notice that was given a while ago, and it just kind of lives on and lives on and lives on. So I think this is a positive move. John mentioned earlier that he'll touch on some of the ones where government and labor agreed and business and labor agreed on certain things. This was one where there was actually a bit of agreement there in terms of the 24-month period. So I see this as a positive move. I see, obviously times change, the reason for protest change as well. And when you've got that 24-month limitation, I think it's a good thing that then NEDLAC has that oversight to, kind of reissue those notices, if we can call it that as well, every so often, so that it doesn't just lie and live and live and live. So I think it's a positive move.
Okay. John, do you think this helps prevent outdated protests, as Daniel's alluding to, or does it stifle workers' rights?
No, it's and here's a very unbiased opinion.
Please.
This is a very biased opinion. I'm kidding. No, look, I think 24 is enough time. These things get used as a hanging axe, and we need more clarity. I don't think if you want to do it, do it. How bad can your demand or your reason for your protest be if you lie it for 2 years? It's unfortunate. Yeah. I'm in total agreement here, and I'm glad if you read it, it seems that there is rather consensus on okay, this will give more stability. So no, I think it doesn't stifle rights. You have a right, use it, and use it or lose it.
The trade unions have been roaming free for too long regarding this. Do you think that they'll be unfairly restricted, or how do you think, if you put yourself in the trade union shoes, do you think it really makes a difference, as you say, the hanging axe, or do you think they're more in agreement to update it?
I think 24 months is plenty. I don't really think, I don't think a unionist would really feel that affected by it. I'd love to reach out. I know the motor industry negotiations are going on right now, so you won't be able to get hold of Erwin Jim or something like that. But it would be great to hear his inputs, from NUMSA's side and from those type of sides in regards to this. But I don't think, as I said, I think it's a long period. 24 months is a lot can happen in that period. So no, I don't think it stifles rights at all.
I'm going to keep a mental note of inviting him to our podcast at some point.
I think he would actually come and come and join as well. I don't know if Spay Sabotsa is watching, but if you do see this, Spay, reach out. Let's make it happen.
Shout out, guys. All right. Startup business exemptions from specifically bargaining councils. Daniel, again, your realm. Should startups with fewer than 50 employees be exempt from bargaining council agreements? What are your thoughts?
Yeah, this place has been in a very difficult position, as someone who sits and chairs council, but then also advocates for the rights of small employers. It's really like two almost diametrically opposed kind of ways of thinking. I think from the outset, though, any kind of mechanism that allows easier, if we can call it easier business for a small business, should definitely be put in place. I think doing business is difficult in this country as it is, especially as a small business. So when it comes to any kind of mechanism to do that, by all means, I think we should look at that. The problem is when you look at, and they're specifically looking to amend Section 32 of the LRA, which then allows, in a nutshell, bargaining councils to extend their collective agreements to everyone in that sector or that industry. And I mean, the main rationale behind that is to create this perception of a level playing field, that everyone starts on the same place, we all pay the same wages for the same thing. So the moment you allow any kind of difference, if we can call it that, between what I have to pay and what a startup might have to pay, it inherently conflicts with that whole concept of a level playing field. I think there maybe exists a different mechanism to try and resolve this. I know some of the bargaining councils are already looking at it in terms of the exemption procedure, where instead of this blanket exemption approach based on you being a startup or a small business or whatever the criteria is, that the process for exemption for a small business is made more streamlined. So it's not just this automatic kind of exemption that's applied, but it's more of a procedural thing without obviously too many speed bumps, but it makes it easier from that point of view. I think that's the way forward, not necessarily this blanket exemption. I think it's going to open the door to too many kind of wheeling and dealing.
My next question. So, I mean, obviously, this exemption period for startups, it supports business growth, which in principle, in an ideal world, is great. Think of it as a tutorial section. You've now entered it. Obviously, the goal for most businesses, to grow, more employees, more profit, more business being done, all of that. But I mean, 50 employees is also quite a high threshold. You get a lot of successful companies that operate with a lot less people and, profit driven as well. Now you're sitting in this exemption period. Do you think maybe that should be a time frame placed on that? You can only be qualified as a startup for the first 6 months or whatever, which leads me to my question that I want to ask now, Daniel. Do you think large companies could get away with restructuring as startups to make or to benefit from this?
Well, you see, that's kind of the first thoughts I had about this as well, was there's going to be numerous ways of proverbially getting around this whole thing and registering as a startup, but actually acting through a larger corporation or something like that. And I know even when looking at the report and the reform and, the different things that were considered by the various parties at NEDLAC, one of the things that was mentioned was, but as you say, you could be a small business, but a highly profitable business right from the beginning kind of thing, So where does that level playing field element then come back into it? It's going to take an immense amount of regulation and an immense amount of the bargaining councils as well and their compliance teams really digging into those startups, which is going to take a lot of time. It's going to take a lot of expertise. So
resources.
I don't know. Resources as well, which councils really don't have. So I think it is open to exploitation, my honest opinion. I think it is a good idea. The intention behind it is good, but perhaps it just needs a different way of practically playing itself out.
I think, and John, I'm going to open for your comment now, but I think that if you had to slap a time frame on it, you can only be qualified as a startup for X amount of time. Otherwise, it's just, you're a startup into perpetuity. And I'm thinking of, a lot of online, for example, in the gaming industry, a lot of projects and publishers come out as these startup companies. They've got this project, they look for funding as a startup, they get funded externally by the public, and you just keep on rolling your projects as a startup. John, your thoughts?
Yeah, I think I don't really think I can add on what Daniel's saying. It's so difficult to really find that sweet spot in trying to help the smaller guy. But again, just as you say, a person with 40 employees is maybe not that small. These could be very large companies and with very high turnover. And how do you protect big business whilst also protecting small business? So it's a very difficult one. I've been playing around with ideas, and I've been thinking, maybe the council should rather exempt new employees for a while. So you have a 3-month period before you have to register and comply. But again, now you are a startup. You don't have to pay. You don't have those overheads in the first 3 months versus the big guy. If you have a company, you're literally registered just for that contract. It's a 6-month contract, and for 3 of those 6 months, you don't have that extra, expenditure. So it's very difficult. The intention, good, as Daniel says. I don't really have more to say about it. I think it's a very difficult place to play to help and to protect and to ensure compliance and to avoid loopholes. There's a lot of facets going into. It's not a small thing, this.
I see the comment sections are quiet today on this topic. I don't know if it's because it's a Friday or because it's just the NEDLAC and people maybe just listening rather than wanting to give their input. But I would love to hear from public opinion. What are your thoughts on this? I think it's a very difficult thing to balance. If you look at what a small business needs versus what a large company needs, to balance those two just off each other is extremely difficult, and play it off against what the law should predict and regulate. Guys, moving on to temporary employment, fixed-term contracts, and part-time work. Daniel, so I feel like I'm in an interview here. I see we do have a comment. Okay, hold on over here. Okay, never mind. I think it's a bit of spam in the chat over there. Thank you for your Friday blessings from Winston Ali. We appreciate it, but due to it not being labor law related or to this conversation, we will not be dealing with your comment, but we appreciate the engagement nonetheless. All right, Daniel, should fixed term and temporary contracts have longer exemption periods?
Again, it's a difficult one. Yeah.
Do you want me to add on first? Get a bit more specific. All right.
Be more specific, well, then we can answer it.
So, business proposed increasing the exemption period from 3 months to 12 months, but this was rejected. Was it the right call?
I think yes and no. I think yes. Okay. We need to look at the history of also, Section 198 in terms of fixed term and things like that, and the protection that obviously comes once that period expires. The whole intention behind that was that employees aren't abused, and that obviously employees don't have rights taken away from them that they should have been given in the first place. And 3 to 12 months it's a big jump. When you look at that and how it practically plays out and the protection that's afforded to employees. I think 3 months is potentially still a bit short, especially when we start looking at deeming provisions and things like that. Potentially the 6 month spot was a bit more of a sweet spot, and I think that was what was kind of proposed as a median between the parties. So 12 months maybe a bit too long in terms of especially protection and vulnerability, but I think 6 months would have been a better kind of middle point.
No, I actually agree with you on that. So I'm not actually agreeing, but I do agree with you on this, Daniel. I think it's strange that, the current stance is 3 months. It's weird that they didn't budge at all, not even to, anything between 3 and 6. I think 6 would have been a sweet spot. Jean-Andre, maybe your thoughts, and if you can maybe explain to our viewers what the current stance on fixed term contracts is, just to provide a bit of context.
Yeah, let me oppose you guys here. I don't think it was necessary to change it. I think the 3 months is enough, and I think Section 198B gives you enough protection on if you're doing it correctly. So firstly, obviously, the current stance is there's a 3 month period before you really get into the nitty gritties. But 198B does give you certain regulations where you can go beyond that that 3 months, and it also then gives the protection if it goes over 2 years. So I think moving it from 3 to 6 to 12 is irrelevant. People who are going to misuse it and do it incorrectly are going to misuse it and do it incorrectly. It could be 10 years. It doesn't matter. I think the protection is there. 3 months is fine. You could have exceptions with larger employers, but I think in your bulk of it, 3 months is enough. If you're doing temporary contracts correctly, you shouldn't be in trouble anyway. I don't think the time frame for me is that's not the thing we struggle with if we have disputes. The period is not the issue. It's the why am I putting these individuals on temporary contracts? That is, so if you're using 198B correctly and you are acting within the law, as an employer, you have enough protection. As an employee, you have enough protection. I don't think that, for me, in a practical sense, I don't think that period would really affect any of my officials doing disputes based on temporary contracts. So just my opposing view.
No. I welcome the opposing view. So you've touched on something now that we experience a lot at the CCM and the bargaining councils, is that employers, not all of them, but where there is a misunderstanding, they sometimes confuse how a temporary contract works, or a fixed term contract, or limited duration, whatever hat you want to put on it. It is what it is. They confuse that with probation, or they use it instead of probation. Daniel, what are your thoughts on that?
Yeah, I think this is something you're right, Carl. We've experienced, on a few occasions. And it's that misunderstanding between the real purpose of a fixed term contract. And the real purpose should be, as Jandra mentioned, those protection mechanisms for both employers and employees. The reason, the timing, project, whatever the case might be, as opposed to the probation being the trial period. It's I want to actually employ you here for an indefinite period of time, but to make sure that you fit this role, or your expertise and your skills line up to the role, the probation is that trial period. And they're two very different things. And, unfortunately, there have been instances where, because of misusing it, you don't come out on the better side at the CCMA, as a result of it, because of that misunderstanding of the two. So it is unfortunately something we do experience, and the two are quite different. Although you'll always find that the fixed term contract generally goes for that 3-month period, which just happens to be the same amount of time as the probation period that would have been used, very coincidentally. But yeah, two very different things, and obviously need to be treated very differently as well.
I think the fixed term contract it's the wrong thing to do if you want to test someone for probation, but it's an easy out. Oh, sorry, you don't fit, you're incompatible, you're not competent enough, you don't meet the technical requirements, whatever the reason is. It's like, oh well, I know you're done after 3 months anyway, so cheers. And that is actually the wrong use, as you say. You need to look at the core, the reason behind why a fixed term contract exists, the core of why a probation clause or a probation period exists, and they're completely two different procedures. And to alleviate the pressure that a company might feel from someone who's not making it during the probation period, you have to still follow those procedures. The obligation is on the employer. So I think your guys' opposing views or on all of that really helps. I think create different opinions.
Yeah. Carl, can I just jump in on the misconception? Because I also think it's one of those things before the protections were there or before the regulations were there. Your dad used temporary workers on this basis, so and a lot of people haven't caught up. But yes, we see that it's a misuse. And the question is very simple, and that's my first question when we consult with an employer. Why is he on this temporary contract? Why? If it's because I wanted to check if he was okay, you've got problems. I need to be able to link it to a tangible service or a project or a period. It has to be seasonal. Listen, the potatoes need to be harvested this period. So that's why it's there. I have a retail shop. November, December, January, we are at capacity. I have a restaurant on the beachfront in Camps Bay. Listen, it's December. We're gonna rock it out. So there needs to be a tangible reason. Me just wanting to check his services and see if he can do the job. Go back to Schedule 8. There is a mechanism for you there.
Yeah, I think 198, if you look at the Labour Relations Act, 198 subsection 4 deals with exemptions. It's very easily laid out there. It's not confusing to read at all. So, I can just refer our viewers and employers to or engage and invite them to have a read through section 198, and I think they'll get their clarity there. Guys, moving on to minimum wage and deferred payments. So this one is a bit where the government, Labour and business strayed. Should bonuses and deferred payments count towards minimum wage? Now, bear in mind, the minimum wage is now increased as of the 1st of March. Business says yes, bonuses and deferred payments should count towards the minimum wage. Government and Labour said no. Who's right?
Let me go and let's go controversial. Obviously the government will say no because they need to increase the minimum wage to keep up with inflation. So with all of that and with all the tax on all the employees and with the new VAT being proposed, that additional amount must come somewhere. And where must it come from? The employer's pocket. And that is why they disagree here, in my humble opinion. It's easy to say, listen, well, this is your annual basically bracket, or even if you have a look at the threshold, but now we're playing around with it because we're trying to be the nice guys and say, listen, you have to pay this amount to keep up with inflation and make sure that people have a basic wage, which I still feel the current minimum wage, although places a lot of strain, if you look at the price of things, yes, it's not a lot of money, but this is exactly the government shows their card here. We can't keep up with the inflation. We can't bring food prices down. We can't bring petrol down. You as the employer, please put in it needs to come from your pocket. And it's a very emotional thing when I read it because that is my opinion. What is happening here? We have a national minimum wage, but let's exclude things from that so that the employer is paying the bulk. What will be the result? Bonuses are going to disappear. That's going to be the result.
I think the government is seeing it very short term in the sense that they're trying to fix a problem now, but they're creating a much bigger problem later on. It's the same with the increasing cost of goods, inflation, all of these things. And I want to think of it like the country as a car. You need to pump the brakes, switch off the engine for a while, fix whatever's going on, and then carry on. And, unfortunately, countries don't work like that. But there's a fundamental flaw in the system because we keep on pushing and pushing and pushing, but yet things aren't rising, or money's not coming in as quickly as what we're spending. And same for companies. And you're looking at your retrenchments, you're looking at your 2-week severance pay and all of that as well. And then this just adds to that. Take out bonus payments. There was a case, Quantum Foods, I believe, where So that case specifically dealt with the definition of remuneration, saying that even your provident payment that goes to the employee, ultimately, it might not receive it now, it still counts towards remuneration. Daniel, how do you think all of this could affect minimum wage workers?
Yeah, look, I think one of the first questions that started popping out when the national minimum wage came into effect, and more specifically Section 73, and we started dealing with these matters at CCMA, when was it? Way back in January 2019, I think, was this concept of, but all right, I might pay him or pay the employee R2 less per hour, but at the end of the month, they get a bonus kind of thing, And when you look at that, he's earning, or the employee at that stage is earning more than what the minimum wage, stipulates. And that's basically what Quantum Foods revolved around, is that whole concept. And at the time when I think that judgment came out, I still saw that as a win for the employer, because it was quite a big move. I think at the end of the day, we need to look at minimum wage and what the purpose of minimum wage is. I do a commentary on the minimum wage from a CEO perspective every year. And one of the things that's always very prominent is the fact that your minimum wage earners, a large portion of what they pay out to actually go to work in the first place, something like transport, is a huge chunk of what that money coming in actually goes out to, So, it's a difficult one because obviously the effect is felt right at the bottom in terms of those that actually receive it in the first place. So, but I still think at the end of the day, if we look at it holistically, if we look at it, if we're looking at it as a month period or a 12-month period or something, if what the employee is getting is the minimum wage or more, then that's what should be considered, not just the minimum wage in isolation, because I don't think that was ever the intention. And I think Quantum Foods showed that as well.
No, 100%. I'm just thinking of the wasted expenditure now. We're talking about money and the budget. You're increasing the minimum wage. You're wanting to take out bonuses, but you're also increasing tax. So ultimately, for lack of a better word, you're screwing the employee constantly, and the company has to fork out the difference. But listen, I see we have a comment over here from Tsidi. Fixed term contracts have a specified end date. However, in some industries or jobs, the end date may not be provided, resulting in a successive type of contract. And so this term may be unfamiliar to some commissioners. I found myself questioning my argument regarding the absence of an end date because she confused it with seasonal contracts, which it was not. You want to take this?
TDF, thank you very much for the, sorry, Daniel. TDF, thank you very much for the comment. Look, if you go and look at Section 198B, it doesn't always have to have a specific end date. It can be project-based. We look at construction, and I'm using one of our members now. I won't name them directly, but they build in phases. So you've got phase 1, phase 2, phase 3. So obviously phase 1 would be foundation, and it's a lot of digging and it's excavators and stuff like that. Then those guys move, and it doesn't have a specific end date because obviously it depends on weather conditions. You have breakdowns, you have contingencies, all of that. So as long as it is specified and it's clear, listen, you are here for phase 1, which is the foundation phase, and you as the company you need to track it so you can give the necessary notice. And I know this might be an unpopular opinion. Some people will tell you, listen, no, but I just let you know it's the end. I say be safe. If that contract is within just the 6 months or that project, give your 1 week notice. Listen, we are terminating on this date. But make sure that you specify the actual project that we're working for. It's a very simple thing. Listen, you're appointed to pack 100 boxes. But I mean, now it takes you 3 days, but now it rains in the middle of the day and it's 4 days. But ultimately, once the 100 boxes have been packed, you terminate. So it must just be clear, and it mustn't create a perception of permanent employment. So it's all about that clause in your explanation in the beginning. And make sure, and I advise employers as well, when you have that temporary clause on a project base, make sure that the employee signs there as well, so that they understand that's what it's for. So it doesn't always have to have a specific date. You can, and I invite you to go and have a look at Section 108B. It gives you specific mentions. It does have that last little caveat of any other reasonable section. Don't use those. Use the 10. So yeah, that's just my response to the comment.
Yeah, just to add there, I think if you can be as specific as possible, and as long as you can substantiate and reason with the extension, and it ties into Section 198, subsection 4, the exemptions, then you're fine. I see Adrian over here had posted the SAFI link, and I'm assuming, I can't see which case it is, but I'm assuming that's the Quantum Foods case. So thank you very much for assisting us there.
Shout out to Janssen van Rensburg attorneys here in Bloem.
Best criminal attorney you could ever find. All right. Listen, guys, moving on to pension and benefit fund contributions. Daniel, should there be stricter enforcement on employees failing to pay pension fund contributions? And I'll add, Labour and government want the interest penalties. Business says it's already covered under the Pension Fund Act. Thoughts?
Right, yeah, so I think there's two ways of looking at this as well. Obviously, pension contributions in the normal course. And when I talk about normal course, I mean companies not maybe falling under a collective agreement, because obviously those collective agreements under bargaining councils will be enforced with regards to their compliance and agents and things like that. My personal opinion from off the bat is there is enough regulation around this already as well in terms of the Pension Fund Act. We don't deal with it too often, but if I recall correctly, I think it's Section 13, if I'm not mistaken, of the Pension Fund Act actually makes it a criminal offence to not contribute the contributions on behalf of the employer and employee, obviously, you know. So, I mean, that's already quite a strict imposition or strict penalty that's involved there for non-compliance. So I tend to agree with what business says there in terms of, you know, there's already enough regulation, there's already enough potential consequence for non-compliance.
Yeah.
So in terms of the interest as well, I think that's also covered. So it seems like almost a double punishment that wants to be imposed for non-compliance. Look, I know there was a report that came out, was it last year, from the FSCA about how many companies are non-compliant. And it was quite a shocking statistic to see, you know, but I feel there are already mechanisms in place to address non-compliance. So it shouldn't be yet another hurdle.
Yeah,
no, I agree. John, any thoughts?
Yeah, I agree. The mechanisms are there. On the one hand of the amendments, you want to lessen the burden, and on other sections, you want to extend the burden. It's a bit counterintuitive, but I think the mechanisms are there. And as Daniel says, I mean, it's a criminal offence. You can be arrested.
What more penalty do you want on an employer? All right, guys. So this is bringing us to the end of the key aspects that are covered, and it introduces the most fun section for me. I get to watch you guys squirm a bit under the quickfire. So, yes, no answers only, and I'll tell you when you can substantiate. Jean-Andre, before we close, we're going to have a few of these questions, and I'll bounce between the two of you.
Shoot.
Should high-earning employees lose the right to reinstatement when unfairly dismissed?
Yeah.
Okay. Follow up on that. What would you put that threshold as a high-earning employee as?
Yeah, that's difficult. I think, let's say, you have to look at stats. You'll have to see who uses the CCMA and who has, and sorry, I know it's a yes, no, or a number. I don't have that information, but I think you need to do a proper study of, listen, this is the amount that you could access courts easier. You can, and as I said, you have other dispute resolution options and the price of it, and have a look at, listen, where is the wage discrepancy actually go, or the wage bracket that mostly uses the CCMA. I think it's an act in futility, this amount. In my mind, I think that bracket, if you want to alleviate stress from the CCMA, it needs to be very low. I don't think anyone over 600 to 800,000 in a year is really using the CCMA that much. So you'll have to look at the stats.
So interesting, you said 600,000, which works out to 50,000 rand a month. So I actually went and looked at the stats for you on this. So according to the latest stats, and it's about a year or two behind, if you are earning about 50,000 rand a month, you are already in the top 8% earning capacity in South Africa. Does that change your opinion?
No, I think that reinforces it. I think I don't think people are using this. I don't think you're going to lighten the burden at all. You might shorten the processes. Yes, you might force individuals into settling more because that you don't have that reinstatement hanging. So employees might be a lot more amicable to say, well, I'm going to sit in the courts for 3 years. I'm not going to get it. My maximum compensation for dismissal is 12 months. I might settle earlier. It'll lessen that blow, but it'll be between the parties. I don't think it'll alleviate the courts or the CCMA at all.
Daniel, so CCMA commissioners can issue up to 12 months their jurisdiction for unfair dismissal matters. That 12 months currently doesn't have a cap. Would you put a cap on it, and what would that amount be?
I think you would. If you're going to place a threshold on what the higher earners can then do, I think you need to have a correlative cap as well. And I think that cap needs to match whatever the threshold is that is determined at the end of the day. I think that will probably be the most fair basis.
Genre, do you think it'll be fair to match that cap with the civil court's jurisdiction?
Yes, I've always found it extremely interesting that a commissioner can give an award an amount higher than a magistrate.
Would you equate that amount to a magistrate?
I'd equate it to the magistrate court. If you look at the hierarchy of courts and the justice system, I would cap it. I would give it exactly the same jurisdiction as a mag court.
Okay. Daniel, unfair labor practices. So the proposed changes, and we didn't deal with it here because it wasn't so big, but they want to remove promotion and demotion from the ULPs. Do you think balancing employee and employer rights, do you think it's fair to remove those two?
No, I don't think so.
Okay. Do you think that...
This is a quick fire round of questions.
It is. So. Okay, I'll leave it at that. No follow-up. Okay. Yeah. Genre, does a 3-month qualifying period for unfair dismissal protection make workers too vulnerable?
No, there's enough mechanisms to protect them.
Daniel, will increasing severance pay from 1 to 2 weeks per year service hurt job creation?
No, I don't think it'll hurt job creation.
Okay. For businesses considering the financial implications of retrenching, how do you think that'll go down, Daniel?
Obviously, the complete adverse effect or opposite effect. I don't think, just maybe to add on, I think when you're looking forward, you're never looking or envisaging retrenchment. So I don't think that's really high up on the priority list, when you're moving forward. I think it's one of those things that comes in the back end and you're like, oh, my goodness, we didn't think of this kind of thing. So I don't think it will necessarily hurt job creation because of that.
Yeah. So some of these questions are just recapping what you guys already, put your opinions on. But Genre, does limiting protest action notices to 24 months unfairly restrict workers' rights? Nope. You did answer this already. Just checking. I'm actually just testing your guys' answers with some of these questions to make sure that you still stand on the same point. Daniel, should startups get a free pass from bargaining councils for 2 years?
No.
Genre, would extending temporary contract exemptions from anywhere above 3 months have been a better move?
Well, I was already saying that.
Should bonuses and deferred payments account towards the minimum wage? Daniel?
I'm still going to say yes on this one, Cole.
Okay. Are stricter penalties for unpaid pension fund contributions necessary, or is the current law enough? Genre? You're muted.
Oh, sorry. Can you hear me now?
I can hear you, can't, sir.
Okay. No, it is. I think there's enough. There's enough penalties currently.
Okay. Daniel, will these reforms actually improve workplace fairness, or just complicate labor law even more?
Yeah, that's a big question to give a yes or no to, Cole.
I need an absolute here.
No, you're
I defer to Genre.
I'm going to take mine. The intention, yes. With the intention, yes, I'm going to say.
Okay. And the practicality?
No.
Okay.
Yeah.
Genre, Are employers likely to find loopholes in these new laws to avoid compliance?
Well, there's always loopholes to be found, my friend. There's no legislature in the world that can block everything. So yes, there will always be loopholes. If this will create more loopholes, yet to see. We first need to. What does an advocate always say? I haven't been paid to see the loophole yet. So no, we'll see when if it does come into practicality. You'll then see the loopholes. But yeah, any law, there's no law without loopholes.
Any good attorney will play with those loopholes as much as they can to their benefit. I see we have a question over here. I'm interested in Daniel's reasoning behind the no on startups. Daniel, would you like to take this one and elaborate?
Absolutely. So I think it's when I mentioned when we discussed about the bargaining councils and this issue of startups. I think to create a blanket exemption or an automatic exemption, if we can call it that, for a startup, it's just too problematic in terms of compliance and the playing field going forward. I think there needs to be a mechanism for the startups and for small business, but through the auspices of bargaining councils' collective agreements, not through an automatic or blanket exemption. So the idea or the concept, I think, has traction. It's how it practically plays itself out with the mechanism that's used to allow it to play out.
Okay, great.
I hope that answers to you.
Yeah, no, it's a very honest diplomatic approach. I mean, we need to look at it from both sides. I know we're an employers organization, but in order to advise correctly, we need to look at the adverse as well. Guys, my final question before we wrap up today, if there are any questions from the audience, please feel free to pop them through. Even if it is after the fact, we will address them. Looking at the labor law reform process and how the stakeholders or the parties that were elected for government, labor, and business, those parties came together. Do you think that is a fair reflection and an equal reflection on the larger voices in South Africa? Do you think that their say encompassed what the majority of business, labor, and government want? I'll ask you both individually.
Yeah, I think so. You can only make it so representative, instead of, because too many voices also creates chaos. I think my larger concern is if you look at where there were agreements and disagreements, there's a lot of agreements on procedural and framework stuff. But go and look at, if you really go down that list and you see where labor and business are on some of the financial and I call it the nitty-gritty things. I think that's just concerning, that there's still quite a huge divide between business and labor. And I don't know if it is because business is just, becoming stricter because of what's going on, or if labor is just so far separated from how a business actually works. And I won't say it's one or the other, but the fact that they're still so far apart on a lot of things is a bit concerning for people who live and work in the labor sphere. It's very nerve-wracking for me, and that's something I've picked up.
We hope your nerves will be put at ease soon, Chandra. Daniel, please give me a conflicting opinion here.
No, I was quite worried you would ask this question, if I'm honest, Cole, because I think we've also had discussions about how the NEDLAC, in terms of the different constituencies, how they are comprised and how they go about being there and whatever have you. But, look, I think we also need to look at it in the context in which it's coming up. The world of work is changing, and it's constantly changing. So even when you're looking at reforms and looking at developing new law to kind of adjust with something that's changing, that's also going to change eventually as well. So I think for the most part, the ideas are good. Like even answering CD's question, the intention is good. It's practically how we play these things out, So the representation that's there, look, that's its own separate process that happens, through NEDLAC's constitution and the act and how people sit there and whatever have you. But, nonetheless, I would be more worried if we weren't moving forward. I would be more worried if we were kind of just stagnating and doing absolutely nothing, as opposed to trying to address problems, whether it does it rightly or wrongly. I don't know. That's why we have these conversations. But I would be more worried if we were stagnating. So, yeah, a bit of a political or politically correct answer, I hope. But my thoughts.
Yeah, honest. I appreciate it. Gentlemen, that brings us to the end of today's panel discussion. I really appreciate you guys' time. From my side, if there are any other further questions or comments, please feel free to put them through. Thank you guys for the engagement. On the last question that I asked, this NEDLAC reform process is up for public comment. So please, if you have an opinion, put it through to us, send it via email. Our details you'll find on our website. Please like, share, and subscribe, as always the YouTubers and the influencers say. But follow us on LinkedIn, follow us on Facebook, Twitter, Instagram. We're across there on all our social platforms. If you like this kind of discussion, please give us your thoughts. From my side, going to wrap up this Friday. It's been a good one. Thanks, gentlemen. I really appreciate your time.
Thank you very much, everyone.
Thanks, Paul. Thanks,
Cheers,
everyone.
everyone.